the outset, then you need to be aware that there are fair reasons for dismissal, such as redundancy. However, in terms of taking employment tribunal proceedings, the types of dismissal are unfair or constructive dismissal. Unfair dismissal is when the employer has made the decision to dismiss you and they have to prove that the decision they made was the correct one in all the circumstances. A constructive dismissal case is one where you, as the employee, have made the decision that you wish to resign and write your letter of resignation based upon something the employer has done that has made you reach that decision. The starting point is that they should have a dismissal process, and you should be contacting your employer and asking for a copy of the disciplinary and grievance procedure. If they don't have a policy in place, then I would be suggesting that you look in the first instance at the ACAS website, as that contains lots of information on what would be expected in terms of an employer's process for disciplining and dismissing an employee. No, there are terms of qualifying employment in terms of unfair dismissal claims in most situations. There are exceptions to that, so if you find that you have been dismissed, it is always best to seek prompt legal advice. You must follow what's called the ACAS pre-conciliation process. You have to follow that before you're able to start employment tribunal proceedings. That is a free service, but you should also seek independent legal advice at the earliest opportunity, and your solicitors may deal with that process for you as well. What you need to do is file what's called a grievance, which is a letter setting out the reasons why you feel discriminated against and what you would like your employer to do about that. There should, in addition, be a grievance policy in place. So you should ask your employer for that if you don't have a copy of it, or investigate where they've got it on the intranet or a hard copy somewhere. Follow that process. If not, again, follow the ACAS website. That's got some good guidance. But in essence, you need to set out in writing at the earliest opportunity when you're feeling that there is an issue, and put it to your line manager in the first instance. So this arises when an employee and an employer have got issues and they're looking to terminate the agreement. It would normally be at the suggestion of the employer. These discussions leading up to settlement agreements are known as what are called protected conversations, when you negotiate the way of bringing your employment contract to an end. The answer to that question is it depends upon the type of claim you're trying to bring. In unfair dismissal cases, for example, it's 3 months from the date of termination, but be aware that that could be not the date you received the letter confirming the date, but actually the date you had a conversation with your employer dismissing you. For other types of cases, the time limit varies, so it's always best to take legal advice as soon as possible.